the media and members of the public, I think it's very necessary that we make very clear what happened in court today. We do not want to call it a travesty of justice because of the respect we had for the judiciary, but we are utterly disappointed that today bail was refused. On what grounds? The Supreme Court on 15 December criticized very severely the revocation of Mazi Nnamdi in several pages, which we are going to make available to the media. At pages 19, 20, and 21 of Justice Agem's judgment, he even suggested that the impartiality of the trial court in revoking Nnamdi Kanu's bail is suspect. We didn't mind all of that, but still we made an application, a fresh application, to my Lord, urging her to exercise discretion to restore Nnamdi Kanu's bail. She refused it without any reason whatsoever. And then we made a second application to accentuate the need for this bail application, pointing to the enormous challenges we face as defense counsel in consulting with Nnamdi Kanu privately and confidentially at the detention facility of the DSS headquarters in Abuja. We are only allowed 30 minutes each as counsel on only Mondays and Thursdays for a cumulative period of 2 hours, twice a week, to consult with him separately. And the federal government is feasting to have an accelerated trial. Yes, we too want an accelerated trial, but we have to have it under an environment that respects Section 36, sub 6, B and C of the Nigerian Constitution. It's all about fair hearing. It goes to the ground norm. It goes to the basic norms of the society that you must hear the other side. And to hear the other side, he has to have an adequate facility to prepare his defense and to consult with his lawyers. It's the Constitution that said it. It's not us that said it. So we came to my Lord with an application and said, listen, it's impossible for us to conduct this trial under this atmosphere of interference with his right to counsel. They eavesdrop on our conversations. In the little cubicle room of 10 by 10 where we consult with Mazi Nnamdi Kanu, they have secret listening devices and secret photographic and videographic devices. They listen to our conversations secretly, they take our secret photographs, and we adduced this evidence before my Lord. They confiscate our legal documents. They don't allow us to take notes. Pray. You may be lay men and lay women. The general public may not be lawyers, but is this fair? How can you have trial under circumstances like this? It's not possible. So we are not stalling. It is the federal government that is stalling. We can't take notes. So what is the essence of it? We cannot prepare him adequately. We cannot talk with him. We whisper. We put our lips to his ear. We talk sotto voce, and so on and so forth. So this is the essence. This is what happened in court today, where justice was turned upside down when our 2 applications that go to fair hearing were refused. But we are going to bounce back. There are more applications to come.
Are you going to appeal on this ground?
Yeah, definitely. Appeal is ongoing as I speak. Today, by tomorrow, appeal is filed.
Okay, excuse me. Please, in addition to that, yes. Please. Yes. In addition to that, what happened today is an act of Federal High Court overruling the decision of a Supreme Court. I want you to get it right. Because the Supreme Court said, Nnamdi Kanu never jumped bail, that the court ought not have revoked that bail on the application of the violator of his right, that is the federal government. You cannot benefit from your own wrong. And we thought that the Supreme Court would have exercised its power under Section 6 of the Constitution to make a consequential order directing that Nnamdi Kanu should be released. But they directed that the trial should be continued here, and we should make an application. Of course, we ought not have made any application. Court should have exercised his power discretionary and released Nnamdi Kanu. That they never did. Then, secondly, which is the most fundamental, I have been going there to visit Nnamdi Kanu. They never allow me to exercise my right as counsel to Nnamdi Kanu. my right was violated, I took DSSS to Federal High Court.
1.5 million.
Federal High Court warned DSSS, ordered them to apologize to me, and ordered that they should pay me 5 million naira for close to 2 years now. They have not paid that money, and though I just allow it, that's why I have not enforced it, because 70% is running on top of it. Nobody has appealed against it. So now we filed the same application before the court. It's in the court file, asking my Lord to prove that we are not free. Where court has even taken judicial notice of that, but all to no avail. Now the court said that we should apply, since we cannot transfer Nnamdi Kanu to Kuje prison, stating that there is no security at Kuje prison. So that we are now applying that Nnamdi Kanu should be detained, should be remanded in a private house. And we are suggesting Abia State Government House or Abia State Liaison Office. So that is the application. So that is it.
Wait.
Franchement, c'est très bien pour rester upstairs.
I want to thank the press, okay, for keeping the struggle alive.
Yes.
Now, I must tell us something. What happened today in this court is almost like an opportunity lost to bring peace, immediate peace, to the southeast. The Supreme Court had given the Federal High Court the opportunity to bring peace to the southeast.
And they lost
and
it.
Unfortunately, they are toying with that opportunity given to them by the Supreme Court. All that the Federal High Court need was to go back to the ruling of the Supreme Court and follow it and give back the bill it had previously withdrawn. And then you will see absolute peace in the southeast. But with what happened today, it's obvious that certain persons don't want that peace to return to the southeast. And we are imploring members of the public to please continue to interrogate the reason why the Supreme Court judgment of 15 December 2023 will not be complied with by a Federal High Court.
Yes.
We need a Federal High Court to simply obey the orders of the Superior Court. A court, look, you did not employ the judges of the Supreme Court for the sake of employing them. Whatever word they utter from their mouth touches on something fundamental. And in this case, in other circumstance, what is fundamental is Nnamdi Kanu did not jump bail. You have no reason to have revoked his bail. Restore it. And the Federal High Court is kind of toying and playing around with it, thereby continuing to create the chaos in the southeast, thereby continuing to make the federal government waste money. Do you know how much the federal government is spending every day Nnamdi Kanu coming? They told us they spend 500 million naira. Somebody is signing off that check. Somebody is signing it off. Who is signing off? Who is making money from it? Extra allowances are being paid to all the security men who are in Abuja because of Nnamdi Kanu.
It's your money.
Wait, and we have been saying the case of Nnamdi Kanu is not such that we need to spend scarce resources on. The federal government is crying about money. They don't have money, but they have all the money to pay all the security agencies. If you go outside, not less than 1,000 security agencies are on patrol in Abuja because of one single man. And tomorrow they will tell us they don't have money to pay salary of workers.